U.S. trade court blocks Trump's sweeping tariffs. What happens now? The Court of International Trade ruled that the Trump administration lacks the authority to impose tariffs on nearly every country in the world. The ruling states that the 1977 law cited by the White House to support its power to impose sweeping tariffs does not apply to the current situation. What did the 1977 law say? The International Emergency Economic Powers Act, IEEPA, grants the president broad authority to regulate economic transactions during a declared national emergency. This act builds upon the Trading with the Enemy Act introduced during World War I. However, a three-judge court panel ruled that the economic concerns cited by the White House to justify the tariff plans do not meet the required test of being unusual and extraordinary threats. The ruling was based on two distinct cases, one brought by the nonpartisan Liberty Justice Center on behalf of several small businesses that import goods from countries subject to the duties, and another brought by a coalition of U.S. state governments that were also affected by the import taxes. What happens next? The White House has 10 days to complete the bureaucratic process of halting the tariffs. However, it shouldn't be a problem because most tariffs are currently suspended anyway. The White House has announced its intention to appeal the ruling. The White House argues that the three-panel judges lack the authority to issue the ruling because they are not elected by the public. The exact nature of this difference remains unclear. If all courts uphold the ruling, businesses that have had to pay tariffs will receive refunds for the amounts paid, with interest. This includes reciprocal tariffs, which were reduced to 10% across most countries and increased to 145% on Chinese products, now at 30%. It's worth noting that a higher court might be more favorable to Trump. After all, the crux of the matter is whether we are confronted with unusual and extraordinary threats. The truth is, the underlying reason for the policy might be concealed due to the fear of a skyrocketing national debt. Whether this constitutes unusual and extraordinary threats is a judgment that demands exceptional economic knowledge, which not every judge possesses.